Hello everyone, welcome to the channel Unlock Law Online English. Advocate Kritika here today with a video all about the judgment Arnesh Kumar versus State of Bihar. This is a very landmark judgment which provided guidelines that has to be followed during the arrest. Now let us look at this judgment and understand what are the facts and what is the court says and what is the judgment. To start with, I would always suggest you to read the judgment instead of notes or the summary that has been provided by others. That is because the perspective changes and also what you are looking for in a particular case or in a particular judgment would be differing. Therefore, it is always advisable to read the original judgment if you're looking it for application in any of your cases or if you're making any case notes. To start with, Arnesh Kumar versus State of Bihar. This judgment was passed by Honorable Supreme Court of India under the Criminal Appeal 1277 of 2014 and Special Leave Petition Criminal number 9127 of 2023. So the citation is also very important. That is because this may be asked in any of your examinations. It may be judiciary or it may be even in the UGC net law. Moving next, let us read the judgment. So this judgment was delivered by Chandramouli K.R. Prasad. And also once again, if you are preparing for any competitive examination like UPSC or UGC NET, this could be the question as well. Moving next, let us understand the facts of the case. So what happened in this case? So basically, I have summarized the facts here. Arnesh Kumar is the husband of Mrs. Shweta Kire, and they got married on 1st of July 2007. He was under an apprehension that he will be arrested under complaint of 498A IPC and Dowry Prohibition Act. She alleged that she was harassed for dowry from her in-laws and husband and was also thrown out of matrimonial home. Hence, he applied for anticipatory bail, which was rejected by Sessions Court and as well as by the High Court. So, as a last resort, he has approached the Honorable Supreme Court of India as a special leave petition. So, this is all about the facts that I have summarized from this judgment. Now, in the first initial paragraphs, you can find the facts that are of the case. And moving next, let us understand what are the allegations that are put forth by the wife. So she has alleged that they are demanding rupees 8 lakh, a Maruti car, air conditioner, and television set. And also the mother-in-law and father-in-law were also brought into the picture. Moving next, the judgment has explained that what has happened and why did he decide to make an anticipatory bail application. So this was rejected by learned session judge and therefore by the High Court. So now the court jumps into its observation. So it has said that Section 498A of IPC was introduced with the object to combat the menace of harassment to a woman at the hands of her husband and his relatives. So here it has said what is the significance of 498A. So the basic objective of 498A is to help the woman to protect herself from harassment caused by her husband as well as the relative. And it also stated that the Section 498A is a cognizable offense and non-bailable offense. And also it has said that this has been used as weapon rather than a shield. So here this is a very elaborative word. Like instead of weapon, they are using it as a shield. Like it is given to protect you, but it is being used as a tool to harass the other party. So moving next, the court has explained that how the quite number of cases this has been brought into light. So it has even mentioned about the statistics that are provided by Crime in India 2012. So how the unfair arrests are made and how people are being harassed and all other things. So its share is 6% of total persons arrested under the crime committed under Indian Penal Code. That is, they are not liable and many other things. Like it has given the clear pictures of all. Like if you are looking for this video in perspective of preparing your dissertation, then I think all of these things would be of really great help. And then the court has interpreted arrest. So it has said that arrest brings humiliation, it curtails freedom, and casts a scars forever. Like it has said that, yeah, arrest is like, yeah, this person has been arrested. It is always a stigma that would be associated with him. And also, it gives a permanent black mark on him, like, oh, he was sent behind bars. And also, it said that the law also knows this, and also the police also know this. And there is a battle between the lawmakers and the police, and it seems that police has not learned its lesson. So now here they are taking charge of the police, and they're telling that they have not learned their lesson. That is, in spite the fact that the court has said and the lawmakers have said it several times, especially in CRPC as well, the police have not adhered to it. And also, it stated that the IPC is very old. Despite 6 decades of independence, it is largely considered as a tool of harassment, apprehension, and surely not considered as friend of public. Okay, so CRPC now will have a new one, but however, the court has opined that it is not a friend of public. So moving next, it has spoken in length about the arrest and other things. And also, it has mentioned about the recommendation made by the Law Commission, Police Commission, and others. And also, it has set its observation that we believe that no arrest should be made only because the offense is non-bailable and non-cognizable, and therefore lawful to the police officer to do so. So it is said that just because it is a non-bailable offense and a cognizable offense, and the police officer has a right to do it, he need not do it. The existence of the power to arrest is one thing, and the justification for the exercise of it's quite another. See, you may have the right, but need not necessarily that you have to execute or show your right at all times. Apart from power to arrest, the police officer must be able to justify the reasons thereof. Yeah, not just arresting, but he should be able to justify the reason. No arrest can be made in a routine manner on a mere allegation of commission an offense made against a person. So just because somebody is alleging that he has done that, you cannot arrest a person. It would be prudent and wise for a police officer that no arrest is made without a reasonable satisfaction reached after some investigation as to the genuineness of the allegation. Like it is reasonable. That is, it has to be followed that the police officers are making arrest by doing some basic investigation, by doing some basic check lines, and also check how correct the allegation is. Only then they should be making the arrest. And also, the court, moving further, spoke about it in length along with quoting the provisions of CRPC. So the first provision that they quote is Section 41 of CRPC, where it says that when police may arrest without warrant, a police officer may, without an order from the magistrate and without a warrant, arrest any person. So, an arrest warrant is not required in these circumstances. So, Section 41, Clause 1, Subclause A has been removed, and Section 41, Clause 1, Subclause B, it provides certain guidelines against whom a mere reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine, if the following conditions are satisfied. Namely, so it has laid out certain conditions. So again here, first one has been repealed, and we have second one. The police officer is satisfied that such arrest is necessary. First one is to prevent such person from committing any offense further. Like he should be arrested because he would commit another offense. For proper investigation of the offense, that he may tamper evidences or do something, or it is important that he should be in the jail. To prevent such person from causing the evidence of the offense to disappear, tampering with such evidences in any manner, prevent such person from making any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the police officer. or as unless such person is arrested, his presence in the court whenever required cannot be assured. That there are chances that he may elope, and the police officer shall record while making such arrest the reason in writing. Provided a police officer shall, in all cases where the arrest of a person is not required under the provisions of the subsection, record the reason in writing for not making the arrest. So he should be following these guidelines, and also he should be making the answers in writing. That is, the answers should be written so that it is being recorded. And the court, moving further in the judgment, has interpreted the particular section, and it has explained the provisions in detail, like what does it says and what it is not, and all other things. Now, as a part of this judgment, it has laid four questions to the police officer before making any arrest. The police officer before arrest must put a question to himself. The first question is, why arrest? Why is he doing the arrest? Is it really required? So whether he has to really arrest him, what purpose it will serve, like what is the objective behind it, what problem it is going to solve, what object it will achieve, like what is the object that is it is gonna achieve. So these are the four questions that the police should ask himself, and he has to have answers for all of these four questions. I'll repeat once again. The questions are: first one, why arrest? Is it really required? What purpose it will serve? What object it has to achieve? So these four questions has to be answered by the police officer to himself before making any arrest. And moving further, the court has explained the provisions. Okay, the police has answered all the four questions, and they are uh, justifying that the arrest is required. So what should be done immediately after the arrest? An accused arrested without warrant by the police has the constitutional right under Article 22, Clause 2 of the Constitution of India and Section 57 CRPC to be produced before the magistrate without unnecessary delay and in no circumstances beyond 24 hours, excluding the time necessary for the journey. So he has to be produced before the magistrate within 24 hours. So this is one of the guidelines that it has to be followed and it has to be adhered. Moving next, so it also has said that what are the provisions that has to be followed during the investigation and during his time in jail, and what is a magistrate supposed to do, and all of these things in detail and in elaborate fashion. Okay, moving next, going to the next paragraph, it has said that the evidences that the police officer should produce to the magistrate and all other provisions. And then it has spoken about section 41A of CRPC, where it says notice of appearance before the police officer. The police officer shall, in all cases where the arrest of a person is not required under the provision of subsection 1 of section 41, issue a notice directing the person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense, to appear before him or at such other place as may be specified in the notice. Okay, so the police officer has to give an call to that person or issue a notice to that person that he has to appear before. Where such a notice is issued to any person, it shall be the duty of that person to comply with the terms of the notice. So if any person receives any notice or any call from the police station to go there, then it is his duty. Where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offense referred to it in the notice unless for reasons to be recorded, the police officer is of the opinion that he ought to be arrested. So if a person adheres to the notice and he visits the police station whenever, however required, he will not be arrested. However, there is an exception. If a police officer feels that yes, he has to be arrested, then he can be arrested. Where such person at any time fails to comply with the terms of the notice or is unwilling to identify himself, police officer may, subject to such orders, have been passed by a competent court in this behalf, arrest him for the offense mentioned in the notice. So if he is not willing to come to the police station or not willing to identify himself that yes, I am this person, then the police officer has a right to arrest that person. Now moving further in the judgment, The judges have elaborated the particular provision, and it says what it is and how it is and all other things. To this, as a conclusion, they have come to the fag end stating that providing certain guidelines. So, in order to ensure that we have observed above, we give the following direction. First one is all the state governments to instruct its police officer not to automatically arrest when a case under 498A of the IPC is registered, but to satisfy themselves about the necessity for arrest under the parameters laid down above flowing from Section 41 CRPC. So it has said that the state government shall instruct its police officers that they will not arrest a person automatically under 498A. Just because a complaint is registered under 498A, the person cannot be arrested. All police officers be provided with a checklist contained specified subclauses under Section 41, Clause 1, Subclause B, Subclause 2. Okay, so we saw that lengthy checklist. So that has to be provided to the police officers so that they can adhere to the same. Police officers shall forward the checklist duly filled and furnish the reasons and materials which necessitated the arrest while forwarding or producing the accused before the magistrate for further detention. So the checklist that has been provided by the state government has to be duly filled and submitted before the magistrate when he is producing the arrested person. The magistrate, while authorizing the detention of the accused, shall pursue the report furnished by the police officer in terms aforesaid, and not only after recording its satisfaction, the magistrate will authorize detention. So the magistrate will review the report that has been submitted by the police officer, and only then, if satisfied, he will authorize the detention. The decision not to arrest an accused be forwarded to the magistrate within 2 weeks from the date of institution of the case, with a copy to the magistrate, which may be extended by the superintendent of police to the district for the reasons to be recorded in writing. So now there are chances that when this power is given, it can be misused. So if a person is not arrested, even that has to be recorded. So that will be forwarded to the magistrate within 2 weeks from the date of institution of the case. Okay, so within 2 weeks, a report has to go to the magistrate that why a certain person is not arrested. So the police officers are responsible even to answer why they have arrested a person, and also to the question why they have not arrested a person. Notice of appearance in terms of Section 41A of CRPC be served on the accused within 2 weeks from the date of the institution of the case, which may be extended by the superintendent of police of the district for the reasons to be recorded in writing. Moving further, failure to comply with the directions aforesaid shall, apart from rendering the police officer concerned liable for departmental action, they shall also be liable to be punished for the contempt of the court to be instituted before High Court having territorial jurisdiction. So if any of the police officer they fail to adhere to this guidelines, then suit for contempt of court will be instituted before High Court having territorial jurisdiction. So it is very important for the police officers to follow this particular guidelines. Authorizing detention without recording reasons, as aforesaid by the judicial magistrate concerned, shall be liable for departmental action by the appropriate High Court. So if the judge also does this, that is without any proper reasons, they are giving the detention, even then they are liable for the departmental action. So it is not just police officer, it is even the judges are held liable under this particular provision, okay, under this particular guidelines. So these 8 guidelines are very stringent, very strict, and very straightforward. And also the court, to remove all the confusion, it has said that it shall not only apply to the cases under Section 498A or Section 4 of the Dowry Prohibition Act, but also all such cases where offense is punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine. So now the people shall not be under a doubt or under an apprehension that because this was passed under a case instituted seeking anticipatory bail in Dowry Prohibition Act, but this guideline shall be applicable to all the cases wherein the punishment that is awarded shall be less than 7 years or which may extend up to 7 years with or without fine. And also, as a closing remark, it has said that the judgment will be forwarded to the Chief Secretary, also the General Director General of the Police of all the state governments and the union territories, and the Registrar General of all high courts for onward transmission and ensuring its compliance. So this judgment that was passed by Chandramurali K.R. Prasad and Pinaki Chandra Ghosh on 31st October 2023 set a landmark in case of the arrest by the police officer for all the offences where punishment is 7 years or extend up to 7 years and with or without any fine. So this is all about the judgment. I hope this was easy to understand and I covered all the 21 pages of this Arnesh Kumar judgment. If you have any questions, do let me know in the comment, or if you feel that I've missed any part or I should have emphasized any other part, please do let me know so that I could incorporate these changes in my upcoming videos. Thank you for watching. And yes, please do not forget to like, share and subscribe to the channel Unlock Law Online English. Coming up with a ton of videos about check bounce cases. So stay tuned and do not forget to subscribe to the channel and also share with your friend. Thank you for watching.